I'm here today to talk to you about Stark Law. Stark Law puts limitations on specific physician referrals. It prohibits physician referrals of designated health services for Medicare and Medicaid patients if the physician has a financial relationship with the other physician. A financial relationship exists if there is ownership, investment interests, and/or compensation agreements. It refers any form of oral, electronic, or written communication with other physicians. Stark Law prohibits DHS services to be made while gaining some form of compensation. DHS services include things such as supplies, prescription drugs, consultations, inpatient/outpatient hospital services, etc. The Stark Law can be found in the U.S. Code Title 42, Section 1395 pertaining to Social Security. There are three parts to the Stark Law. Stark 1 barred self-referrals for clinical lab services under Medicare. The provision was made in the Omnibus Budget Reconciliation Act of 1989, OBRA 1989, which became effective in 1992. This included exceptions for legitimate business arrangements amongst healthcare facilities. The OBRA of 1993 expanded the referral restrictions to include additional health services and apply to Medicare as well as Medicaid. This created the Stark II. It set clarifications and amendments that were added to Stark 1 and also created a list of exceptions in order to make interpretation a little bit easier. The Stark II also had many healthcare professionals that argued the Stark I and Stark II intruded and impeded on their medical practices and were unwarranted. Healthcare managers argued that the compensation arrangements were too confusing and too intricate to manage. Stark III was created during the Balanced Budget Act of 1995. It created the third part of the Stark Law, and there was two major changes: the repeal of the prohibitions based on compensation arrangements, and the second is the reduction in the list of health services that were not allowed by the former Stark legislation. The Stark Law is not the same as the anti-law kickback.
As a clinician in a privately owned physical therapy practice, the Stark Law is actually very beneficial to us, because the Stark Law only applies to physicians who refer Medicare and Medicaid patients for designated healthcare services to entities to which they have a financial relationship. So for us, they usually do not have a financial relationship, so it's a beneficial act. To determine the Stark Law, you have three questions you want to ask. You want to ask, does this arrangement involve a Medicare or Medicaid referral from a physician or a family member of a physician? The second question being, is the referral for a designated healthcare service? The third question would be, is there a financial relationship of any kind between the referring physician and the entity to which the referral is being made? With all these three questions, if the answer is yes, then you need to determine which arrangement it falls within and to see if the exception applies. If it does fall within an exception, you're usually good. If it falls in a category where there's no recognized exception, then the Stark Law does apply to the situation and the referral does violate the federal law. The benefits of the Stark Law to us as a private clinic is that it stops physician-owned clinics from monopolizing the physical therapy realm and being able to refer all their patients in-house or to a designated provider. It ensures the quality of care by assuring that the patient is sent to a provider who would provide the best service, not just to one of their people where they'll increase in money from this referral. It also stops patients from becoming a piece in an assembly line in large clinics where it's all about volume and turnover rather than quality care. There's several prohibitions with the Stark Law. The Stark Law prohibits a physician from making referrals for a certain designated healthcare service that's payable by Medicare to an entity with which they have a financial relationship or with which their family member has a financial relationship. It prohibits the entity from presenting claims to Medicare or another payer for those referred services. It also establishes a number of specific exceptions and grants the Secretary the authority to create regulatory exceptions for financial relationships that do not pose a risk to the program or patient abuse. When I talk about designated medical services that are to be referred to, this includes laboratory services, physical therapy, occupational therapy, speech and language pathology, any imaging services, medical equipment, prosthetics, orthotics, even prescription drugs and hospital services. So this covers a very broad base of what the referral can be put towards and what could actually be a violation of the Stark Law. With the Stark Law, there is a system to monitor what's going on. Monitoring is used by facilities to determine whether the Stark Law is implicated by a relationship with the physician and whether any financial relationship with that physician is permissible. There's several steps to monitoring. The first one is to ask, is the physician involved? Have they made a referral to a designated health service? Is the service or supply payable in full or in part by Medicare or Medicaid? Is there a direct or indirect financial relationship with this entity, meaning financial relationship or even a family member? And you need to ask if an exception applies. These steps are asking us to monitor, again, the financial relationship of the physician, if they're providing money, providing gifts, if they're having them participate in any type of facility-sponsored training program, or if they're paying their medical director's compensation that exceeds the fair market value. We want to make sure all the services for this facility is reasonable and necessary. To answer these questions when monitoring for Stark analysis, we need to review financial relationships with the physician to ensure that when an exception is met, it's taken into consideration. You need to find out whether the medical directors have a written agreement that includes a term of 1 year or more. You need to find out whether the company has a written policy for sponsoring physician or physician office participation in compliance training. And you want to see if that facility has a written policy addressing non-monetary compensation provided to physicians. This includes a mechanism of tracking the amount of non-monetary compensation provided to each physician during the year. You want to make sure that all this is documented and that it's documented being reasonable and that it's consistent and there's an objective determination of fair market value to ensure that the needed services are being rendered. When you find the results from the monitoring, you want to make sure that it's turned over to a compliance officer and a legal counsel so they can evaluate it and respond. The facility should then modify the policy and procedures based on these findings so they can train or retrain the relevant staff. The results should then be provided to the company's legal counsel to identify the problems, take corrective action, and establish a plan for ongoing review and monitoring of corrective actions. Now, with this monitoring, we also think of whistleblowing. And whistleblowers they become a primary action under the Federal False Claims Act because of the lack of government initiation on the Stark Law litigation. The whistleblowing actions have actually helped advance the law, interpreting the state statute, as well as achieving and recovering on the behalf of the government. It deters healthcare fraud in a sense. The penalties you're looking at for Stark Law violations is when a physician makes a referral that is prohibited and no exception applies, then the Stark Law penalties can be imposed. Sanctions for violations of the Stark Law include no billing, refunds, denial of payment, civil money penalties up to $15,000 per service for those submitting claims in violation or not making the required refunds. Penalties of $100,000 for circumvention schemes. This is where physicians enter into an arrangement that have the principal purpose of ensuring referrals to an entity in violation of the law. Physicians and entities can be excluded from participating in Medicare and Medicaid programs as well. These punishments can be imposed on the organization or designated healthcare service entities that receive the prohibited referral.
A Stark Law argument from a health care provider in a privately owned therapy clinic. I am now here to provide you with the Stark Law point of view from a healthcare provider in a physician-owned practice. As previously stated, Section 1877 of the Social Security Act, also known as the Ethics and Patent Referrals Act of 1889, and is commonly referred to as Stark Law. Many physicians are against Stark Law because of the limitations it sets on their practices and the many guidelines that must be followed in order to operate within the constructs of this law. main concern for healthcare personnel regarding Stark Law is that many of the guidelines are complex, confusing, vague, and many consider it a major hassle to develop administrative systems which will ensure that their practice becomes and remains Stark Law compliant. In addition, many healthcare providers find it unfair that the financial penalties and fines associated with violating the law are so high, considering that it's so difficult to understand and follow. According to the Social Security Administration website, violators should expect a fine of up to $15,000 for improper claims submitted and up to $100,000 per arrangement or scheme which violates the law. To top it off, Stark Law does not apply to all patients. It only applies to Medicare and Medicaid patients. This means that the physician must be extra careful when referring patients to any other health institution because patient X experiencing a health problem with private health insurance may be referred to Clinic 1, while patient Y with the exact same condition may have to be referred to Clinic 2 in order to avoid breaking the law. Many healthcare providers have turned to electronic health record systems to generate a customized list for every patient that provides the acceptable healthcare institutions which doctors can refer those patients to without violating Stark Law. However, Tony Thorne argues that the legislation in place hinders the smooth transition into electronic health systems. Whereas the Medicare Modernization Act of 2003 was proposed to assist in transition to modern systems, but state language was seen as a major risk for many healthcare providers. The Act added an exception to Stark Law as long as the information of these electronic records was available for community-wide health information systems. However, the term community-wide raises several questions in the medical field because of its ambiguous meaning in medical practice. Several healthcare providers question if they would be violating Stark Law if their data was accessible to one competing hospital but not another. Due to these high fines associated with Stark Law, many healthcare providers are approaching electronic health record keeping very cautiously. Another overwhelming factor associated with Stark Law is its exception list. The list is considered to be overwhelming because of its length and seemingly unclear language. Currently, there are over 20 exceptions to Stark Law. In addition, there appears to be many overlapping segments in the exceptions which further complicate the decisions of healthcare administrators. Most of the exceptions fall into three main categories: fair market pricing, volume of referrals made, and compensation for referrals set in advance. Fair market pricing implies that referrals must be made to a party which charges the general market price. The volume of referrals specifies that the compensation amount that the physicians receive cannot be related to the number of patients that the patient refers to a specific institution. Finally, the third category includes exceptions which state that compensation for physician referrals to a specific institution must be set before the physician begins referring penalties. At this time, you should be seeing all 22 of the exceptions on your screen. Many supporters of the Stark Law claim that healthcare providers can avoid violations associated with it by carefully reviewing in detail the details associated with the law and seeking the advice of experts in the field. However, administrators may want to do more than that to protect their institutions. The Toomey healthcare system is currently involved with the judicial system, and it is disputing several fines and penalties that it has received, totaling up to actually over $200 million. The fines associated with the Toomey medical system are regarding a $39 million claim that is submitted for Medicare patients that doctors have seen at the institution. The unsettling detail in this case is that the Toomey healthcare system has established a system which they thought charged fair market value for its services, but in addition, they sought the advice of an expert in the field. This compensation expert determined that it was unlikely that the financial arrangement between Toomey and its specialist was violating Stark Law. sum it all up,